Hi everyone, in this session we are going to discuss about Trade Union Act 1926. So let's get to the introduction of it. The starting point of trade union movement in India can be traced back to the year of 1890. In 1890, for the first time, some Bombay mill workers formed an association in the name of Bombay Mill Hands Association. This was formed for the following grievances of the Bombay mill workers. After the First World War, there existed industrial unrest and economic discontent which led to a number of strikes. The payment was very poor, and as a result, strikes were common. The trade union movement in India got impetus by the success of strikes in India and worldwide uprising of labor consciousness. The establishment of ILO, that is International Labour Organization, has also influenced the growth of trade union movement in India. After independence, democratic spirit grew in Indian citizens. The need for legislation for dealing with the labor issues was deeply felt. Mr. N.M. Joshi, the General Secretary then of All India Trade Union Congress, moved a resolution seeking the introduction of some laws for protection of the trade unions. The Trade Union Act was passed in 1926 with the effect from 1st of June 1927. So though it was passed in 1926, it came into effect from 1st June 1927. The Trade Union Act encourages and recognizes the doctrine of collective bargaining. If a particular employee makes a demand, it will be unheard by the employer. But if a trade union espouses that issue, it will be achieved or compromised. The Act was amended in 1942, 1951, 1960, 1964, 1970 as well as in 2001. So after its establishment in 1926 and it came into effect in 1927, it was subsequently amended in 1942, 1951, 1960, 1964, 1970 and 2001. The Act recognizes trade unions as legal entity and confers some immunities to the trade unions in India. Thus, the passing of the Indian Trade Union Act 1926 is an important milestone in the history of trade union movement in India. The progress of trade union movement in India in pre-independence days has not been very satisfactory. But during the post-independence period, there has been tremendous trade union activity in every sphere of industry. Now there is hardly any category of workers which has no trade union or union of its own. The Royal Commission on Labour in India had observed this. Trade unionism, to be fully effective, demands two things: A. Democratic spirit and education. So there should be a democratic spirit and education. So this is observed by the Royal Commission on Labour in India. Now it continues. The democratic ideal has still to be developed in Indian workers, and the lack of education is the most serious obstacle of all. The latter difficulty does not arise merely or even mainly from illiteracy. Few trade unions can afford to conduct benevolent work, and the majority find it hard to convince the workers that a subscription is worthwhile except when a dispute is imminent or in progress. Now, trade union symbolizes the following. The first one, workers' right to organize, and it also symbolizes the second, that is their right to press their demands collectively and go on strike if their demands are not accepted. So next we are going to look into the definitions, some of the definitions under Trade Union Act. So Trade Union Act section 2 subclause H. So section 2 subclause H of the Act defines trade union. What is a trade union? It means any combination of persons for the purpose of regulating the relations between workmen and employers, or workmen and workmen, or employers and employees. It includes any federation of two or more trade unions. So we have four categories here, that is it can be of workmen and employees. Like we have mainly two categories, not four, two categories. One, it is an association of three types of people. Would regulate association for regulating the relation between three classes of people. What are these three classes? The first class is that workmen and the employers, or the second class is between workmen and workmen, and the third class is between employers and employees. Now that is the first category under trade union. And what is the second category that we have under trade union is like it also includes federation of two or more trade unions. So it can either be a association of persons for regulating the relations between workman and employer, or workman or employer, or it can also be a federation of two or more trade unions. A trade union is a continuous association of wage earners for the purpose of maintaining the condition of their lives. A registered trade union can amalgamate with another trade union and form a new union. Under English definition, the word association is used. Under the Indian law, the word combination is used. The word combination carries a wide meaning. In Performing Rights Society versus London Theatres, Performing Rights Society versus London Theatres, that is in 1924. A society was formed by the authors, publishers, and other owners of the copyright. The House of Lords held that it is not a trade union because the principal object of the society was the protection of the copyrights. Now, another case law, that is National Organization of Bank Workers Federation of Trade Unions versus Union of India and others, 1993. National Organization of Bank Workers Federation of Trade Unions versus Union of India and others, 1993. In this case, it was held that where a federation of trade union is not registered, it is not a trade union under the Act. It is not a juristic person and is not competent to raise a demand on behalf of the employees which can fall in the ambit of industrial dispute. It cannot file a writ petition. So, to enable the benefits of the statute, it has to be a registered trade union, and that was emphasized in National Organization of Bank Workers Federation of Trade Unions versus Union of India in 1993. Now, another case, so that is Food Corporation India Staff Union versus Food Corporation of India, FCCI Staff Union versus FCI. Sorry, it's FCI, Food Corporation India Staff Union versus Food Corporation India. Here, the court held that where more than one union claims representative character, the method of secret ballot should be adopted to ascertain the correct position regarding the membership of different trade unions. Then another case law, that is Sahitya Mandir versus State of UP. Here, the Trade Union Act does not make it mandatory that every union or association must be registered under the Act. The only defect of non-registration is that it cannot claim immunities. So, if you want immunities, you have to be registered, but it is not made mandatory under the statute. Now, Booker versus Bernard. That is an English case of 1964. Booker versus Bernard. Mr. Booker was a draftsman in the design office of BOAC. The design office was governed by the closed shop agreement. It means an agreement requiring every worker to be a member of the trade union of the establishment. Mr. Booker resigned his membership of the union and he refused to rejoin the union. All the workers of the design office decided and informed the management that they would resort to strike if Mr. Booker was not removed from the service within 3 days. The management suspended Mr. Booker and then dismissed him from service. Thereupon, Mr. Booker brought an action for damage against the officials of trade union. The House of Lords held the trade union officials liable. Now, another case, that is Tamil Nadu NGO Union versus Registrar of Trade Union. The union included among its members sub-magistrates of the judiciary tahsildars, and it was held that it is not a trade union. Now, exception. Trade union shall not affect the following. There are some exceptions. The first one is any agreement between the partners as to their own business. The second, any agreement in consideration of sale of goodwill of a business or of instruction in any profession, trade or handicraft. Then third, an agreement between an employer and those employed by him as to such employment, and that is discussed in section 2. So what are the exceptions? That is, the Trade Union Act shall not affect 1. Any agreement between partners as to their own business. 2. Any agreement in consideration of the sale of goodwill of a business or of instruction in any profession, trade or handicraft. And the third, any agreement between an employer and those employed by him as to such employment. Now, the next definition we are going to look into is trade dispute. The object of trade union must be for solving a trade dispute. Trade dispute is defined in section 2G. So trade union is defined in section 2 subclause H, and trade dispute is defined in section 2 subclause G of the Trade Union Act of 1926. It is an act of 1926 but came into effect on 1st of July 1927. It is a dispute relating to any trade matter. So trade dispute is a dispute relating to any trade matter. The Supreme Court observed that an individual dispute cannot by itself be a trade dispute unless the case is sponsored by a trade union or by a substantial number of workmen. So either it has to be sponsored by a trade union or supported by a substantial number of workmen. Now, it is not an arithmetical majority but substantiality of their members which is to be considered. So that was observed by Supreme Court. The expression trade dispute has been defined in the first part of section 2 subclause G of the Trade Union Act 1926 in relation to parties and the nature of the dispute. Trade dispute means any dispute that is between employer and workman, or between workman and workman, or between employer and employers, and such dispute must be connected to the employment or non-employment or the terms of employment or the conditions of the labor of any person. So the dispute must be related to either the employment or non-employment or the terms of employment or the conditions of labor of any person. The definition of trade dispute in the Act is almost identical with the definition of industrial dispute in the Industrial Dispute Act of 1947. For a trade dispute, it is necessary that there must be some difference between the parties as aforesaid, that is, demand from one party and refusal to accept that demand by other party. So that is where when a dispute arises. Now, C.R. Sarathi versus State of Madras 1951. C.R. Sarathi versus State of Madras 1951. In this case, the court ruled that there can be no dispute by the unilateral action of one party, which means that the demand must be communicated to the other party. No trade dispute can be said to have arisen unless an opportunity is given by one party to the other to express or indicate any positive or negative reaction thereto. Now, another case law, that is Newspaper Limited versus State Industrial Tribunal 1957. In this case, Supreme Court held that an individual dispute cannot be treated as trade dispute unless the cause is sponsored by a trade union or by a substantial number of workmen. So this was held in Newspaper Limited versus State Industrial Tribunal by the Supreme Court. Now, Shishir Kumar Saha versus L.N. Majumdar. Shishir Kumar Saha versus L.N. Majumdar 1955. In this case, the court ruled that it does not matter that the dispute is not raised by majority of the workmen, but it should have the support of substantial section. It is, even though it is not raised by the substantial majority of the workmen, it should have the support of substantial section of workmen of the establishment. It is not the arithmetical majority of the workmen, but the substantiality of the number taking up the cause which is to be considered. So it does not matter if the dispute is not raised by a majority of the workmen, and that was held in Shishir Kumar Saha versus L.N. Majumdar, and that is in 1955. Now, Associated Cement Company Limited versus their workmen, and that is a 1960 case. An industrial dispute may be raised by some workmen, and if the dispute is referred to the industrial dispute to the industrial tribunal for adjudication and an award is made, it binds all persons working under the industry. The trade dispute must be real and substantial between the parties to such dispute. In case where the workman of a tea estate raised a dispute regarding the termination of service of a person belonging to a category different from them, the Supreme Court held that there was no industrial dispute. The next case law we have here is Standard Vacuum Refining Company versus their workman 1960. This is a Supreme Court decision. In this case, the workman of an oil company made a demand to treat the laborers employed through contractors as the regular workmen of the company. Supreme Court held that it can be treated as trade dispute even though the dispute is not real and substantial one. Now, the legal character of a registered trade union. It is a legal person in view of the provisions under the Trade Union Act. Person means human being. Legal person means a person to whom a personality is attributed by law. Under the Trade Union Act, it is also a registered trade union that is treated as legal person. A registered trade union can claim certain immunities. Now, next definition we have is appropriate government. So, that is also discussed in section 2. The appropriate government means in relation to trade union whose objects are not confined to one state, the central government, and in relation to other trade unions, the state government. Then we have the definition of executive. Executive means the body to which the management of the affairs of trade union is entrusted. That is, the body to which management of the affairs of trade union is entrusted is called the executive. By what name the managing body is known is immaterial. Thus, only requirement of anybody to be executive under this clause is that it should be responsible for managing the affairs of the trade union. Where the executive committee of the union constituted for management of the union and execution of its policy resolved to espouse the cause of an individual employee, it was held that the objects of the committee are wide enough to cover this resolution. So, appropriate government as well as executive is given in section 2, and we have trade union that is defined in section 2 subclause H and trade dispute in section 2 subclause G. And next we have registrar that is defined in section 2 subclause F and the functions of registrar. So registrar means 1. A registrar of trade union appointed by the government under section 3. So appointed by the government under section 3 and includes an additional or deputy registrar of trade unions. And second one, in relation to any trade union, the registrar appointed for the state in which the head or registered office, as the case may be, of this trade union is situated. Now, the primary function of the registrar is to examine the application made to him for registration and look at the objects of the union for which it may be formed. On compliance of statutory provisions as provided in the Act, that is the Trade Union Act of 1926, he shall grant registration certificate to the union. As a matter of principle, the registrar has no power to declare the election of office bearers of a union unconstitutional. So, the registrar does not have any power. As a matter of right, he doesn't have any power to declare the election of office bearers of a trade union as unconstitutional. Now, Mukund Ram Tanti versus S.I. Raza, Registrar Trade Unions, Bihar. Mukund Ram Tanti versus S.I. Raza, Registrar Trade Unions, Bihar. That is 1962 case. Here, if the petitioner has himself submitted to the jurisdiction of the registrar by requesting him to make enquiry, he cannot subsequently be allowed to raise an objection that the registrar acted without jurisdiction. For once he had availed the opportunity of getting a favor from the registrar, he was stopped from challenging the jurisdiction of the registrar if the result of the inquiry happened to be against him. Now, the next definition we have here is office bearers, that is defined in section 2 subclause B, and section 2 subclause A gives the appropriate government, appropriate authority, and section 2 subclause B gives office bearer. So office bearer in case of a trade union includes any member of the executive thereof but does not include an auditor. So office bearer is in case of trade union include any member of the executive thereof but does not include an auditor. Now, workman, that is defined in section 2 subclause G. Workman defined in section 2 subclause G. Workman means all persons employed in trade or industry, whether or not in the employment of the employer with whom the trade dispute arises. This definition has two ingredients. One, workman means all persons employed in trade or industry. And the second one, it is immaterial that the person employed in trade or industry are not in the employment of the employer with whom the trade dispute arises. The definition of workman embraces in it a dismissed, discharged, removed or retrenched employee also. Further, the workman must be employed in a trade or industry, whether under the same employer with whom the dispute arises or under a different employer connected with the same or similar industry. The next definition we have is registered office, that is in section 12. Registered office in section 12. All communications and notice to a registered trade union may be addressed to its registered office. Notice of any change in the notice in the address of the head office shall be given within 14 days of such change to the registrar in writing, and the changed address shall be recorded in the register to keep in the office of registrar. Now, minors membership. So, Section 21 provides for the membership of registered trade union of a minor, but he must have attained the age of 15 years. So, minor can be a member, but he must have attained the age of 15 years, and that is dealt in Section 21 of the Trade Union Act 1926. But this is a subject to any rules of the trade union to the contrary, and he may subject as aforesaid enjoy all the rights of a member and execute all the instruments and give all the acceptances necessary to be executed or given under the rules. But for the purpose of becoming an office bearer of the trade union, such minor ought to have attained the age of 18. So he can be a member of the trade union, but to become an office bearer, he has to be 18 years, and that is mentioned in section 21. A minor can be a member is discussed in section 21, and a minor who is a member to be an office bearer had to attain minimum age of 18 years, that is discussed in 21A. The minor who is a member of a trade union should be minimum of 15 years of age. Now, proportion of office bearer to the connected with industry. Now, section 22 lays down that not less than 1/2 of the total number of the office bearer of every registered trade union shall be persons actually engaged or employed in an industry with which the trade union is connected. So, minimum 1/2 of the total members should be employed in an industry in which the trade union is engaged or employed in an industry with which the trade union is connected. But the appropriate government may, by special or general order, declare that the provisions of this section shall not apply to in any trade union or class of trade union specified in the order. So that is with the definitions. So that is with the introduction and some of the important definitions in Trade Union Act of 1926. Thank you for listening. Like, comment and subscribe. Please click that bell icon so that you get an update when I upload my next video or a podcast. Thank you.